Welcome to all. I'm absolutely thrilled to see so many names in the participants, familiar names, also names that I don't know. Welcome from wherever you're joining. If you've had to get up especially early to be here, an exceptional welcome. Welcome to all from around the world. So mediating in an uncertain world, and my goodness, yes, it certainly is. What I'd like to do in this presentation that's about 35 minutes is to talk through some of the topics really that are with us right now and how is the world changing. And I think the message overall is one of optimism, that mediation is an amazing tool and it can help us navigate this uncertain world. And there is some good news that governments around the world are buying into this. And I'd like to share with you how the landscape is looking for mediation to be used to help people to move through these difficult times. So here we have a little quote that I think comes straight from those in mental health. Uncertainty is the only certainty there is, and knowing how to live with insecurity is the only security. Yeah, take each day as it comes, live in the moment, accept that we are in uncertain times. And I 100% think that in terms of getting to cope personally with where we are right now, that has a lot to say for itself. But is the answer when it comes to business? Well, I would say probably not, because in business, we need to have a good dose of certainty in order to make decisions. If we have too many conflicts hanging over us that we don't know how they're going to be resolved, we don't know what the cash flow is, we don't know whether an exclusive distributor is going to remain our exclusive distributor. All of these things can make business very difficult. And that's where mediation can step in, because mediation can provide certainty. And actually, the big thing about the certainty is it's in the parties' hands. The parties, as we know, those of us familiar with mediation, the parties decide how they want to resolve the dispute. And actually an awful lot of statistics, have shown, just moved on there as I leant forward, sorry. A lot of statistics have shown that actually people who go to court, even if they win, are unhappy. Why are they unhappy? Excuse me, because they've spent a whole lot of time and money getting to court. So they may have a Pyrrhic victory where, yes, they've won, but have they really won in real terms? So mediation allows parties to remain in control of the outcome. And the other thing about mediation is, of course, it enables parties to focus on economic interests, you know, the real stuff that is there that is driving people, and we can have much more flexible outcomes. So just this weekend, I was hearing of a number of professional services firms in London, large, tall, glitzy office blocks, empty. Not much prospect of them being filled, wishing to negotiate to terminate those leases early. Will the landlords play ball? We have to wait and see. But could those offices then be converted into schoolrooms so that children can have more socially distanced educational experiences? Could they be used for juries to remotely watch court cases, such as is happening in Scotland, where actually cinemas are being used? The jurors are sitting in cinemas, looking at the cinema screen, not watching a film, but watching the prosecution of someone taking place. So that would be a commercial solution where perhaps landlords could sit down with tenants and say, yeah, it makes sense for you and for me and for, frankly, the world, that this office is not left empty right now, and what could we do about that? So let's have a look at my topics here. So I've got a little flow chart here. Firstly, what are the current uncertainties? Let's get the bad news out of the way on a Monday morning. Let's see what they are, but then let's look at, should we have a breathing space? This is an expression which, if you Google, you'll find quite a lot coming up, and I'll talk more about that. But it's basically, it's the good news of what governments are doing to try to help parties just to have a moment to step back from discord and see how to create a way forward. Then I'd like to talk briefly about remote mediations. I saw the result of the poll, interested that I think from memory, the figures were coming in reasonably positive about remediations. I'd like to talk about that in my experience and what I'm hearing from others as well. What are the current attitudes to mediation in courts, public bodies and governments? And then, because this talk is about uncertainty, how do we predict outcomes and how do we make decisions? I'd like to talk about that in the narrow area of mediation, but it would be fascinating if we could talk about that at the level of governments. But there's quite a lot of theory there. And then to conclude really with the bigger picture. How is mediation going to be used? How should it be used going forward to help to deal with the uncertain world? So let's dive in straight away into current uncertainties. I ran out of space on this slide. I mean, I could have filled this with so many things, and I'm sure if I asked each of you, what's the big uncertainty for you this morning, I'd get a whole range of different things. But just to run through a few topics that I think are particularly relevant to us today in the topic of dispute resolution. If somebody has a business contract, how is it going to be interpreted during the pandemic? The common law has been a very popular law in international trade. English law, various Ireland, Irish law are common law situations. The whole thing about the common law is we have very little legislation, and the law is built up by cases, by precedents. And the thing is, we don't really have many precedents right now during this pandemic of how decisions have been made for situations that have arisen during the pandemic. I will tell you about one or two in relation to business insurance a little later, but generally we are in a brave new world, and therefore how would a court interpret, was somebody right or wrong to terminate a contract? Did that force majeure clause really give them the opportunity to terminate the contract? I call them the F words, force majeure and frustration. Frustration, that other legal concept that allows you to terminate a contract because of a supervening illegality. How are those going to be interpreted right now is really up for question. And to be honest, I've seen this before. I mean, the law always lags behind reality. I remember in the 90s when we had the internet bubble and I was chairing conferences talking about e-commerce, and those tech-savvy people would be sitting in front of me in great rows and saying, Rebecca, how do you apply the law to technology? And the answer was, well, we have to do our best, but it is uncertain because right now technology is making leaps and bounds and the law is coming along behind it. But what I'd like to suggest later on is that actually this is an opportunity for governments and public bodies to get together to actually create some laws, some regulation, some ethical requirements such that outcomes at court could be more certain, and some of the issues that are raised by remote mediation could also become more certain. Just a little nugget. The lovely doctrine, I won't talk about law for very long at all, but can't resist mentioning unjustified enrichment. The concept of enrichissement sans cause, or arricchimento ingiustificato in French and Italian. So it's there in both common law and civil law, which basically says, look, let's not declare the contract at an end, but let's see if the parties' relationship can be equitably adjusted by the courts. Lord Denning, back when I was a law student, made amazing inroads with equitable relief back in those days. And this surely must be an opportunity for that doctrine of equitable relief to come into play. But at the moment, we just don't know how it's going to come into play. Will it come into play? And so in the meantime, there's a lot of question mark about legal rights and wrongs, and therefore going for a solution within a mediation that addresses the commercial issues must be the way forward. Other uncertainties, briefly, claims against states. Yes, some bold individuals and indeed companies are beginning to say, look, what you've done at governmental level is inappropriate. You have bailed out certain companies to the detriment of others. Claims for inappropriate state aid. The latest one I read about at the weekend, Simon Dolan, British businessman, launched a legal case against the UK government's massive overreaction, as he calls it, to COVID-19. And he's going to the Court of Appeal. He's been told by the High Court, no, your claim has failed. But he's appealing. And basically what he's arguing is for judicial review that the UK's lockdown rules were the most onerous restrictions to personal liberty in almost 4 centuries and shouldn't be happening. Are we going to see more cases like that throughout the world? So how long is it all going to take? Then, of course, we have the issue of the uncertainty of Brexit. What's going to happen with a whole number of areas: customs, rules of origin, trading and product standards, intellectual property, competition law, a massive area. We've actually got some draft withdrawal regulations already on the table, ready to be implemented if we get some kind of a way forward in terms of the negotiations with the EU. But are they going to happen? Are they not? We wait to see. I'm going to be speaking on that with BPP on the 25th of this month. And then we have the bigger question when it comes to dispute resolution of the Brussels Convention. I can hardly bear to say that unless the UK government manages to negotiate a deal with the EU, the Brussels Convention, which is the super important convention that says a judgment rendered in the UK can be recognised and enforced across the whole of Europe, that system is going to go into the rubbish bin on the last day of this year at 11 o'clock at night. And that will mean that a UK judgment will only be good to go within the UK unless specific steps are taken in each of the other EU countries to have the case heard effectively again, or there is a bilateral treaty. Now, there is some hope there. There is the Lugano Convention. The Lugano Convention is similar to the Brussels Convention. Iceland, Norway and Switzerland have signed up to that. But at the moment, there are too many things being negotiated for anyone to look in detail at Lugano. But if Lugano is allowed to, will allow the UK to join, then we will have a similar situation again with mutual recognition and enforcement of judgments, court judgments, throughout the EU and those extra countries. But it's not looking like it's going to happen for the 1st of January. It may happen later in the year, next year, but we wait to see. And then indeed, we've got at the moment the Mediation Directive, which does a similar thing that says, yeah, mediation settlement agreements made in one country of the EU can be recognised and settled and enforced in other countries. That also is going to go out of the window. That will fall apart with Brexit. But there is some hope on the horizon. There's the Singapore Mediation Convention. Some of you may have been following that important convention's progress. Basically, the Singapore Mediation Convention is the global equivalent of the EU Mediation Directive. And it says, look, if you've got parties in signatory states or the mediation settlement agreement is going to be performed in one of them, then that mediated settlement agreement can be recognised and enforced in those various countries. Now, it was signed last August, a record-breaking 46 countries, significant countries signed: the US, China, India, Malaysia, the Philippines, Singapore, South Korea, but not the UK and not the EU. The thinking apparently being within the EU, it wasn't sure whether each country should sign separately or as a bloc, but obviously that's not going to help the UK going forward. So at the moment, it doesn't, the Singapore Mediation Convention doesn't have effect. We haven't signed up to it in the UK or the EU, but it may still be relevant if you have an international dispute where, as I say, the settlement agreement is going to be performed, or the subject matter of the settlement agreement is in one of those other countries that have signed up. So we wait to see what's happening. So a little bit more bad news before I move on to the good news. Risk of a deluge of DR, dispute resolution, absolutely. The British Institute of Comparative Law had a meeting and issued a concept note soon after lockdown in the UK, and in April issued this note, and they said, look, a winner loser outcome during the pandemic won't take full account of the market and social contextualization of the crisis. So in other words, they were saying, look, binary answers are not what we need right now. And in many jurisdictions, there are procedural rules that already encourage conciliation. Can these be developed further to give a breathing space? So they set the scene there. And something that I think is already there is the Vienna Convention, which says, look, if there is a force majeure situation, if something happens that stops people from performing their contract, then the contract should be suspended, not terminated, suspended for up to 6 months. Now, I saw that in practice as being a really suitable approach when we had the volcanic ash situation. There was the volcanic ash that was all over Europe. Planes couldn't fly. Everybody had to grind to a halt. Now, some businesses who didn't have Vienna Convention terms in their contracts, and by the way, that was most UK, because the UK hasn't signed up to the Vienna Convention, said, oh, volcanic ash, force majeure, we're out of here, terminate the contract. But the point was that 2 or 3 weeks later, when the dust had literally blown over, those contracts were still out of operation and had finished, but actually they could have just carried on. So some companies with long-term contracts that have taken a very long time to negotiate found themselves out on a limb. I would also say that there were some companies that triggered that point to their favor. They were in contracts that they actually didn't want to remain in, and they just went, oh, look, force majeure. Yeah, this is the case, triggered it. Of course, there was a discussion, does it cover volcanic ash? Is that an act of God? But I'm not going to go into that right now. So the provision of the Vienna Convention that allows for suspension due to force majeure rather than termination is something I think that we'll be seeing more. But this approach of conciliation, many have said that COVID-19 has been heralded as a tipping point for mediation. And there have been some really successful stories. Did you know that in Croatia, that was where the first remote mediation happened in Croatia during lockdown? They'd never done it before. So it triggered them into using this method. And many more people have been using remote mediation following the measures that have been put in place to deal with the pandemic. So what about a breathing space? Well, some of you may recognize this character here, Wim Hof. If you haven't, then Google him afterwards. Wim Hof method, this chap who's become very popular and trending since March, combination of meditation, breathing exercises, exposure to cold can help you regulate your stress levels. Arguably, litigants maybe need that. And quite often meditation and mediation gets misspelled, and people do confuse the two. So I couldn't resist to put up a picture of Wim Hof. But it's interesting that this concept, his concept of breathing exercises, it coincides with this approach of talking about a breathing space and this new thinking of allowing companies time. So for example, the first legislation that really came out that was going for breathing space was in Singapore. In Singapore in March, measures were introduced from a legislative basis to give breathing space, offering temporary relief to particular businesses and individuals who couldn't perform their contractual obligations because of COVID-19. In Italy, there was the Decreto Rilancio, which did similarly. Now here in England, we have actually got the breathing space regulations. Yes, they are expected to come in force next year in May, so we have got a little bit of time. The full name is the Debt Respite Scheme, Breathing Space Moratorium and Mental Health Crisis Moratorium, England and Wales regs. What they're actually going to do is give people in debt the right to legal protection from their creditors for up to 60 days. So help is along on the way. We also have the Corporate Insolvency and Governance Act 2020, Coronavirus Extension of the Relevant Period Regs 2020, which help companies in insolvency or on the brink of insolvency, and also gives certain rules with regards to directors' duties. That has been something that's been quite topical. What can a director actually do during these times? So having thought about what are the current uncertainties and breathing space, I'd like to now touch on remote mediations and remote mediation sessions. Interested to see that quite a number of you have already been engaged in remote mediations. I'm interested to hear some of your experiences if there's time during the discussion time after. But from my point of view, they are quick to set up, they're efficient, because people can just join, of course, from the click of a button like you have done today. They are cost effective because they don't involve travel and hotel and all of those things. And they're pretty convenient. People can join when they maybe have been in other meetings. If it's a short mediation of 4 hours, they can go about their daily work for the morning and then jump onto the mediation in the afternoon. Although, of course, they may be busy preparing for it in the morning, but it gives more time. The other thing about a remote mediation, in my experience, is there's less what we call venting in the trade. So venting, it does sound like you're getting the Hoover out, but actually it's people just splurging over the time that they've got about how they feel about things. In my experience, people are being less emotional at the start and using that time to go straight into exploring interests and going into then the negotiation. So people are telling me less about how they feel about things. That means that the mediation is quite often shorter and it is more efficient. But watch this space for a few moments where I have another comment in the other way. And of course, the parties are in control of their outcome. And I think sometimes the parties feel even more in control when they've got their own platform, their own screen, and they are not necessarily in it. They're more at the forefront of the conversation, I think. But the downside about remote mediation is Zoom fatigue. Yeah, I'm sure you've all experienced that from time to time. People don't want to be on a computer all day. So looking out the window, taking a moment to take a breath of fresh air. If there's a bit of green space that somebody can look at, so much the better. I think as a mediator, saying to people, I'm going to probably be with the other group for about 20 minutes. So if you want to go and put the kettle on, do. Giving people an idea of how long things are likely to go on for, how long the mediator is going to be in the other room can be helpful. My other experience is that sometimes communication between the parties, the disputants, and the advisors can be less smooth because they're not actually physically together. When the COVID rules allow, it generally is better if the party and their advisor can be physically together, socially distanced, on one platform, because that means that when the mediator isn't with them, they can be talking very readily to each other. But if that can't be, no matter, setting up a private means of communication can be really good using the telephone or WhatsApp. Now, the downside of the less venting is that people don't feel that they have got things off their chest. For some people, going to a mediation can be the next best thing to a day in court. They've said what it is that they want to say before an independent person, and they've been listened to. So sometimes, in particularly emotional cases, it can be important to still encourage, as a mediator, that others will tell you really how they're feeling, as well as what it is that they want. But remote mediation is definitely on the up. IPOS mediation, the chambers that I'm also with, their figures, remote mediations since lockdown in the UK, in March, a third were remote. 100% April to June, as you would expect, because at that time the UK was in total lockdown, trailing down to only just 95% to October, so only 5% face-to-face. And then November inquiries at the start of November was 76%, but this is now, of course, changing as more stringent COVID measures have been implemented during this month. But just also to mention remote mediation, I'm keen to promote the use of the word remote, because I think when people talk about online mediation, sometimes it can make people think that it's a computer generated answer. We need to keep the idea that indeed we are still being human and people, and it isn't an automated system. So let's just quickly look at the uncertainties of a virtual platform. Well, we've experienced that already this morning when I dropped off for a moment, but all was well. I came back, and I think that's the important thing, you know, to be aware that things can sometimes glitch, but not to let the technology get in the way of the substance of what it is that you're doing as a mediator or as a party or indeed as an advisor. I've even had a mediation when there was a thunderstorm and practically nobody had the connection. So we resorted to our phones, but we got on Zoom on our phones using the broadband. I think some of us might have ended up with slightly larger bills at the end of the month for our phone bill, but so be it. Probably still much cheaper than the travel time. So things can happen. Video and audio, there is that 2-second or 1-second delay. And so interruptions can be more prevalent. And certainly if you have a meeting where you have a joint open session at a mediation, necessary just to be a little bit more patient and just allow for the time for that second delay so that you're not interrupting others. Confidentiality, who else is there? I had a mediation where somebody was helping the party with their technology. When they were still helping 2 hours later, I questioned it and said, actually, you know, this is confidential. Is this person in or out? If they're in, then we need to get them to sign the confidentiality schedule. And then the settlement agreement, making sure how is that going to be signed. I use DocuSign a lot, which is a great method. You put the agreement in and then it can whiz around the various people and they can sign it electronically. Otherwise, exchange of email may be sufficient, or look at something like Scanner app where then a party can scan something back in as an appropriate PDF document. So current attitudes to mediation, I can see that time is running and I have lots I'd like to share with you. So I'm just going to touch on this very lightly to say, yeah, the courts always want us to mediate. The judges are delighted if parties in dispute go away and sort things out amongst themselves. There are lots of quotes of judges. Lord Chief Justice himself in March encouraged that. Public bodies, absolutely lots happening there. There's the European Commission for the Efficiency of Justice who said, look, we need some new rules about conciliation, about mediation, dealing with access to justice. And frankly, if more people mediate, that leaves more time within the courts to settle, to decide the cases that cannot be decided by mediation. So when there's domestic violence, when somebody needs a precedent to be established, for example. And then the governments, I've mentioned already some of the legislation, but you might also want to take a look at the UK government guidance on responsible contractual behaviour post-COVID, which actually talks again about breathing space. And although that's non-statutory, I imagine that that will be cited by parties saying, if another party's refused to mediate in line with all the cases that we've seen, including the football club case that we had, Blackpool Football Club case earlier this year, always re-emphasising that message. If you refuse to mediate, are you on risk for costs later, even if you win? So just 2 or 3 things to share briefly here. How good are people at predicting outcomes? How good are we at deciding what an outcome will be? Well, there's been some research in the US, Randall Kaiser, Beyond Right and Wrong, it's published in that book. And what they looked at were what people decided to do at mediation. And they looked at what was on the table at a mediation. If a party decided not to take that, but go to court, how did it compare? How good were people on the mediation day at predicting what might happen in court? Well, a staggering 85% of parties and their advisors made errors, and they were to their disadvantage. So in other words, 85% would have been better if they'd settled at mediation, often because of the legal costs and the uncertainty. But interestingly, when you divide up those 85% of errors, an enormous proportion of those were claimants and their lawyers, 61%. But the cost of that mistake was not too disastrous, 8 to 12%, compared with defendants and their lawyers, 24%. But the mistake there cost them a staggering 150 to 225%. So defendants quite often are worse at assessing the outcome. Why is that? The psychological cognitive bias of loss aversion. It always seems that something will cost us, is worth more when we have to give it up. I could say lots more on that. And indeed, moving on to how do people make decisions, how do we create certainty? As mediators, we are there to facilitate people to make decisions. How are the best decisions made? If you haven't yet got a copy of this book and you've got a little bit of time in the next few weeks, perhaps some of us do have. I know Wales, you're coming out of lockdown, so maybe you're going to be out doing a little more. But this book, Thinking Fast and Slow by Daniel Kahneman, excellent book. I'm sorry, lawyers, it actually says that too much analysis does not necessarily lead a party to the best conclusion, because the party needs to look at all the pieces of the jigsaw. So the legal rights and wrongs is an important part, but other parts such as propensity for risk, health, well-being, future prospects, all of these things are in people's heads. And actually, Daniel Kahneman says the best decision is one made pretty intuitively. So lawyers advise, but be aware that possibly the party may not necessarily 100% follow your advice because they're going to be looking at the bigger picture of it altogether. So insurance, time is running out here, so just share with you this test case brought by the Financial Conduct Authority, looking at business interruption clauses in business interruption insurances. And so we now have some certainty about 8 different versions of business interruption insurance. Does it cover the pandemic or not? I say we've got some certainty because we're waiting to see whether they're going to appeal that case, but that's something else that people often turn to in times of difficulty. So mediation skills in an uncertain world. What should we be doing? Well, I would say let's use them in our daily business and our daily lives. Let's use those mediation tools and communication skills to combat the pandemic as a business tool. What needs to happen? Well, I would love to see more being done at governmental and public policy level to encourage mediation, to give it more regulation, to deal with some of the ethics, such that then mediation will happen more, people can get certain results, and also the courts can be freed up to hear the cases where people really do genuinely need to be heard. Those vulnerable people for whom a remote hearing is just not going to work. I was hearing the other day of a case where there were going to be 8 people on a telephone call deciding the custody of a child. That's a very difficult situation. So the bigger picture, how can we use our mediation skills in a bigger picture? Well, I think that the better communication that is made with regard to compliance with COVID regulations, COVID steps, the more those steps are communicated by politicians in a way using mediation communication tools, people will hear it, people will listen, people will take it on board better. And then getting consensus among politicians, nation states of the UK, if there could be greater cooperation there, again, using mediation skills. And then moving on to the Brexit situation, and then indeed globally. The WHO has been making a lot of pronouncements, but are all the nation states buying into what the WHO is saying? Not always. Perhaps now we will see greater unity now that the US presidential election is over and we can all genuinely come together. So thank you so much to all of you for your time. It's been a real pleasure to share these thoughts with you. There we are. Wherever there's change and wherever there's uncertainty, there's opportunity. I believe there's opportunity for us, for example, at the UK level to sign the Singapore Convention. These were my topics. I hope you found it interesting. In conclusion, life is uncertain. Eat dessert first. I say mediation is the dessert of dispute resolution. It hits the sweet spot. It finds solutions that other dispute resolutions can't find.